In today's world, we hear a lot about no-fault divorces, but that begs the question, does fault still matter? Does it matter why the marriage ended? Does it matter that your spouse cheated or abandoned you or abused you? Does the court still care? The answer is sometimes yes. In this video, we'll discuss what a fault-based reason for divorce is and how it'll impact your case through spousal support, property distribution, and child custody, and how to use all of this information to protect your rights. So before we speak about what a fault-based reason for divorce is, let's briefly touch on no-fault divorce. Most states, including Virginia and Florida, allow no-fault divorces. What that means is you don't have to prove that your spouse did anything wrong to get a divorce. All you have to do is prove that your marriage is irretrievably broken. But just because you don't have to prove fault doesn't mean that it can't be beneficial for you to do so. A fault-based divorce is when you allege that your spouse's misconduct or wrongdoing is the reason why you're getting a divorce. They wasted marital funds, they were cruel towards you, they abused you, they have a severe addiction. All of those are examples of fault-based reasons for divorce in different states. And being able to prove one of these fault-based reasons can leave you to have a significant legal advantage in your case. For example, in Virginia, if you can prove adultery, that's a bar to your cheating spouse to their ability to get spousal support. And there's other benefits to proving fault-based reasons for divorce as well. For example, in property distribution, if you can prove that you're getting a divorce because your spouse wasted marital money, they were addicted to drugs, they were gambling, they spent thousands of dollars on hotels for their affairs, the court may end up awarding you, the innocent party, with more of what's left of your property to compensate for what the other side did. And lastly, if your spouse's behavior negatively impacted the child, the court could limit their time with your child. A common example of this is when you're getting a divorce because your spouse was physically abusive. So again, while it's not necessary to prove fault to get a divorce, it can be very beneficial for your case. But in order to prove a fault-based reason for divorce, you have to have evidence. So how do we get this evidence? Well, for an adultery case, you're going to want to have photos, you're going to want to have videos, text messages, social media posts, all of the above that show the adulterous relationship. If you're alleging that your spouse wasted marital funds, you're going to want financial statements. And if you're alleging abuse, then you're going to want to have witness statements. You're going to want to have police reports. If there's a protective order issued, you're going to want to have that. But as a brief side note, while it is crucial to have evidence for your fault-based reason for divorce, any evidence which is obtained illegally will be thrown out by the court, and it will significantly damage your credibility in front of the judge. Divorce is emotional, but the law is strategic. If you believe that your spouse's actions damaged your marriage, those facts may matter more than you think. Here at Melone Hatley, we don't just file paperwork, we build your case with you. If a fault-based reason for divorce may be a part of your case, contact us today.